Hi again, welcome back. Attorney Steve Vondran here. We are talking about torrents in this video. This video is about Strike 3 Holdings LLC. You can see them right here as the plaintiff versus John Doe, subscriber IP address. There you have it. Okay, this is a case out of the New York Southern District Court in New York. Okay, you have the case citation up here, and I'm going to post on my website, attorneysteve.com, I'm going to post the case law that was cited in this case, which led to the granting of a motion to quash. And when I say motion to quash, we're referring to a subpoena. The subpoena is sent to the ISP to try to get your name and address. And when you're accused of downloading torrent files and sharing them on the internet, they capture your IP. They go to your internet service provider like Verizon or Cox or Comcast, and they try to get your name and address. This was a motion to quash that subpoena, and it worked. So this is something that we want to highlight here and make sure that you get this general legal information. This is not legal advice. It's general legal information only. So this is a really short opinion here, granting. That's the Judge Alvin Hellerstein, and that's the United States District Judge. And this order was granted, so I'm just going to read it because it's really short. Right here, so we have on November 16th, 2017, plaintiff Strike 3 Holdings LLC. That's the main company we deal with. Malibu Media is another video production company that we also deal with. Filed this lawsuit against an unidentified defendant, John Doe, as a subscriber to an identified Internet Protocol IP address. Here's the IP address. Alleging that John Doe violated the Copyright Act of 1976 at 17 U.S.C., that's United States Code, Section 101, by downloading and sharing over the internet copyrighted pornographic movies owned by plaintiff. Plaintiff then moved pursuant to Federal Rules of Civil Procedure 26D for leave to serve a third-party subpoena prior to a Rule 26F conference. So let's stop right there. In federal court, usually there has to be a meet and confer, and the plaintiff and the defendant's attorney go over sort of time frames and timelines and facts and claims and damages. They go over all that and file a report with the court before the parties are allowed to go pursue discovery. But in these torrent cases, they don't have the name of the defendant yet, and so they're just trying to get the name to do an investigation before all that occurs. So this here just says that this is what happens in these cases. Plaintiff moves for early discovery to seek to serve that third-party subpoena on Verizon Fios, in this case, Verizon Fios, the internet service provider, directing Verizon to provide plaintiff with the true name and address of the defendant to whom Verizon assigned the captioned IP address. The court granted plaintiff's motion. So the motion to serve the subpoena on Verizon was granted. So theoretically, Verizon was going to turn over that information. However, one of the things you'll notice when you get an ISP subpoena, a notice of copyright infringement, they will tell you if you don't file a motion to quash or seek a protective order, your information is going to be turned over. So if you need to know more about the motion to quash, we have a video on the motion to quash. You should watch that. Just Google Attorney Steve motion to quash. That'll help you out. But let's finish with the opinion here, with the order. Defendant then moves, subject of this order, to quash the subpoena that plaintiff served on Verizon. So here, this was a motion to quash. Strike 3 opposed it through their legal counsel in New York, and the court said, I'm siding with the defendant. I'm going to grant this motion to quash. It says right here, the motion is granted. The motion to quash is granted. Let's hear that. Let's hear that from our friend.
The motion to quash is granted.
Okay, so the complaint fails, the judge says the complaint fails to provide appropriate copyright registration forms or even list the copyrighted materials, as opposed to merely the site that defendant allegedly infringed on. So this is the key to why the judge is granting the motion to quash. They're saying that Strike 3 Holdings did not adequately describe the materials that they claim were infringing. So let's go over here real quick. Here's the case Strike 3 Holdings in Pacer. I'm going to click on that. If you come in here and go to the history and the documents, run your query, and go to the complaint. This is where you will find here's the complaint, and here's the exhibit. This is the exhibit that the judge is referring to. The judge is saying this is not adequately describing the copyrighted content. So let's take a look at what they say is infringing. So this is typical of what you would see in a infringement report. And really what it's saying here is that the location of the infringer is in New York. There were 30 works infringed. The ISP is Verizon, and here's your IP address. So this is Exhibit A to the complaint, but it doesn't really tell you what the movie is. The movie title's not here. You do have copyright registration numbers over here and dates that they were filed, but you don't know what the movie is. There's a hash identifier. These are hashtags that identify the movie, but the defendant would have no way of knowing what the movies are. And these are the sites they're referring to. Tushy is one of the Strike 3 sites. Blacked is another. Vixen is another. But the court's saying that this did not adequately describe what movies, what works were being infringed. And so on that basis, the court says, according to the complaint, plaintiff owns the copyrights to the works, and the works have been either infringed, the works have either been registered with the United States Copyright Office or have pending copyright registration. The United States Copyright Office registration information for the works, including the registration number, is outlined in Exhibit A. That's what we just looked at. However, Exhibit A, mentioned and attached to the complaint, does not provide such registration numbers, nor does plaintiff's AO 121 copyright form. So by failing to identify which copyrighted materials plaintiff owns and which materials defendant infringed on, the complaint fails to state a claim to relief that is plausible on its face. Let's hear that one more time.
By failing to identify which copyrighted materials plaintiff owns and which materials defendant infringed on, the complaint fails to contain sufficient factual matter to state a claim to relief that is plausible on its face.
Okay, so that is the motion to quash, and that's what you have here. And so you can see on the docket, you have the motion to quash. There was a response, a reply, order on motion to quash, and then we have a voluntary dismissal. So we don't know if, the order on the motion to quash was on the 8th. This was 8 days later. There was a voluntary dismissal. Let's take a quick look at that. So, it's hard to say, but it was voluntarily dismissed. And it's hard to say if they settled or if it was just dismissed and they didn't want to go through it. But that's, into the great unknown. And there's your law firm, the James Law Firm, out of White Plains, New York. So that's a really good case for plaintiffs. So I'm going to post some of the case law that was cited in the motion and in the opposition so you can see that. But it goes to show that there is a grounds where the complaint is not adequate on its face to state what is being infringed, what the titles are, what the registration numbers are, that you could basically win in a motion to quash. How that ends, it's impossible for me to say. It could be a settlement. It could be a dismissal of the case. But that is a motion to quash. Jurisdictions and other grounds. So we do have some, like I said, in some of my other videos, we do have some good favorable case law coming out. It's moving, like a big slow rock that we're pushing up the hill, but we keep on pushing. So AttorneySteve.com for more information, or you find out about this case, just type in Attorney Steve Torrent Defense. You will find us on the web. So I hope this has been helpful. If you like it, please give us a thumbs up. I don't see other attorneys out here putting the kind of information that we're doing out here, so we appreciate your support. If you like our videos, feel free to share them on your social media websites. And don't forget to subscribe to our channel. Let's face it, how much politics can you really handle? So Attorney Steve out. I gotta run. Have a great day. We'll talk to you again. You click, we defend. Take care now.